Hello, I am Noni Richin, President of the Board of the Small Property Owners of San Francisco Institute. Good evening, members, and welcome to what, fingers crossed, will be our final recorded stand-in for a real meeting. This month in the newsletter, we listed many of the statewide bills that we're following, along with our statewide affiliates in the California Rental Housing Association. And some of these bills are pretty appalling, such as the owner move-in restrictions. Of course, we here in San Francisco already have these restrictions in place, but this is an example of the creeping sense of government supremacy over private property in Sacramento, that these would be statewide, even in locales where they're totally nonsensical. Another extreme that is being floated is that owners cannot check credit or employer information. Just brilliant. Many of these ideas deserve a death quickly, and that's what they get. But we have to keep our eyes open. We really wanted to have for the next meeting the new acting director of the Rent Board. She wants to come to one of our meetings and explain the rental inventory that they've created. Unfortunately, the Rent Board meetings usually conflict with our meeting times, so she had to decline. We'll continue to try to find a compatible date. However, tonight you'll hear an answer to a question that was submitted several times. What happens if I don't register? And speaking of answers, the team from Utrecht Law is here to answer your questions. So I'll sign off and let them take over. Thank you for watching. If for some reason you missed one of our sessions, they're all available on private YouTube channels. Just email us at info@smallprop.org and we'll send you a list of all the links. See you soon and thank you. Bye.
Welcome to the Small Property Owners Legal Panel. Presenting tonight will be myself, Paul Utrecht, and Raymond Yetka, my associate. I'm doing my regular admonitions. We're not your lawyers. There's no attorney-client privilege. Tenants and tenant lawyers can listen in on our questions. Those who've submitted written questions haven't heard today's admonition, but with any luck, you've heard prior admonitions at prior meetings, since I've done this every time I've done this presentation for a long time. So we don't want to know your secrets. We want to know things that your tenants already know. A couple of questions are anonymous, so that helps with anonymity, but bottom line is tenants and tenant lawyers can listen to this. I don't know if they do, but they can. And then the other thing is we have a little more preparation time today than I do at a live meeting. And I'm looking forward to live meetings starting in June. At a live meeting, I see the question literally minutes before I answer it. So I've had no opportunity to really think about it or research or do anything like that. Some questions do require more thought than we can give you here today. So we consider this information and education rather than legal advice. If you want a legal answer, you need to get a legal consultation to do that. So having said that, we'll jump in.
A lot of these questions could be a full consult.
Right. So we're giving you the big picture, 30,000 foot explanation of the law and how it exactly fits to your situation, depends. And one of the things that often depends on is the exact wording of your lease. So that becomes something that's critical for us in these cases, usually, or in many of these cases. So we're not seeing your lease. We don't want to see your lease because if you want that level of analysis, you should have a consultation. We still offer 30-minute consultations with an associate for free for small property owner members. To compensate for the inability to grab us in the hallway and the prohibition on grabbing us in the hallway after the meeting. So if anybody decides they want a 30-minute free consultation, call our office and that can be arranged. So jumping into questions. First question is from Marilyn. Marilyn has 2 tenants on a 1-year lease. One tenant moved out before lease expiration and the remaining tenant claims he cannot find a replacement tenant. The remaining tenant stated he will only pay his share of the rent, $1,000, instead of the total monthly rent of $2,000. I have not accepted his partial payment. Can I begin the eviction process, or what is the best course of action at this point?
So as long as there's only one lease for the apartment, there's no reason to take partial payments. And what it sounds like the tenant is saying is he's saying, I have a lease and my roommate had a lease. As long as that wasn't the original deal, you don't want to make that the deal by taking half of the rent. Whether they can replace their roommate is their problem. And the full amount is due. And if they don't pay that on time, that's a breach. So, assuming they do find a roommate, our typical advice is that you make that fully their problem. You don't want to take money from the new person. You don't want to be involved in the agreement between them. It should be the original tenant, subtenant. And you want to give what we call a 614 notice when they do find that roommate to let them know that they're a subsequent occupant and you're going to raise the rent to market if the original person moves out.
Ray, does the lingering moratorium have any effect on this?
So we are in a strange space for the moratorium. The state law stopped San Francisco from having a non-pay moratorium at this moment, but it's coming back.
At this moment, meaning April 1, May 1, what's the start date?
So it's a complicated question because new local moratoriums were paused as of August 2021. Maybe 2020. Don't hold me to that date. At least about a year ago, at least, new cities couldn't do new moratoriums. That prohibition ends July 1. So starting July 1, San Francisco is allowed to have a non-pay moratorium. So for rent that came due up to July 1, you can do non-pay evictions right now, no moratorium at the state or local level. Brian has an economics question for Paul. What is the industry range in San Francisco for rent to gross income ratio? What do those words mean, Paul?
So it's usually called GRM, which stands for gross rent multiplier. The similar calculation the other direction is cap rate. So say a cap rate, just to pick numbers, is 10%. That would mean that the GRM is 10. So it's just one's just flips the fraction. And in a standard non-rent controlled jurisdiction of a property that is an apartment building, and that's the highest and best use of that property, in that environment, properties trade based on the cap rate or the GRM, and that changes over time because it is affected by expected interest rates, current interest rates, and expected interest rates for 10 to 20 years, expected inflation rates for 10 to 20 years, and expected increases in rents for 10 to 20 years. And what owners require to sell their treasury bills, which have no risk, and invest their money in real estate, which has risk. So there will be a market. If the market knew those numbers, the GRM would be standard and pretty easy to calculate, because instead those numbers are all variables. Effectively, the market makes an estimate of all those numbers and then creates a GRM or a cap rate that creates a compensation scheme for the owners that's sufficient to get them to sell their T-bills and pay the down payment. So having said all that, San Francisco, one more thing to understand is that because that's how apartment buildings are bought and sold, your expectation is that at the time at which you decide to sell, your property will sell for that similar kind of calculation. Expected interest rates will be different, expected inflation rates will be different, but the same effective formula from current fair market rent of the unit with calculations based on those variables. And your comfort level is provided by the fact that the GRM or cap rate is established by the collective action of the marketplace. And so owners, buyers, and sellers are essentially creating what the standard rate is at any given point in time for apartment buildings in non-rent controlled jurisdictions where that's the highest and best use. So having said that as sort of background, we come to San Francisco, and the first thing that you all know is that rental rates are not free to move. Rental rates are limited by rent control. So the easy part of that calculation is, okay, well, San Francisco rent control is 60% of CPI. So if it stays 60% of CPI, then we can probably, predict, since our GRM calculation is predicting future inflation rates, we can take that inflation rate and say 60, instead of having rents that run higher than that number, the rents are capped. Now, the rents are capped, but if you have a vacancy, they're uncapped and you get to go to market. And so what has happened in San Francisco is that there becomes a disconnect between the rental rate and the property value, because buyers of property say, okay, I'm buying a 100-unit building. This works way better on a 100-unit building than a 6-unit building, but say I'm buying a 100-unit building and 4 or 5 of them are occupied by people who we expect will live there for the rest of their lives, and they're healthy 60, 70-year-olds, and they're paying 50% of market. Well, great. We can say, we put on our actuarial hat now and say the average life expectancy of a 70-year-old is 25 years or 21 years or whatever the average is. And maybe we drill down to male, female, which are different, and maybe we do some kind of health assessment. And it's also, remember, it's also not just whether they die, but it's also whether they can keep going up the stairs. So anyway, so you can do some kind of analysis of those 5 units, either with a sledgehammer or with a fine-tooth comb. Obviously, every assumption you make into that pool makes you have less. Your number is more precise, but your accuracy is lower. So you can do some just gross valuation of those units. On a 6-unit building with 3 units occupied by those people, now you've got to do that analysis. You can't say, oh, well, we won't count those 5 units, or we'll count those 5 units at half, or we'll count those 5 units at some sort of arbitrarily selected number, because it's 5% of your building. So you're really looking at the other 95% and saying, during the expected tenancies of those properties, rents are capped at 60% of CPI, and when they're vacant, they'll go to market. And in San Francisco, historically, that's been a significant bump up if the tenant has been there for a long time, bigger than capturing the CPI. So some ability to predict that, but with a rent-controlled building with tenants that are not paying market, that are expected to live there for a long time, you have a really hard valuation problem. And so you can't just say the GRM is 8 times the gross rents, and therefore I'm going to buy the building for 8 times the gross rents, because that's not fair to the current owner, because at some point the gross rents are going to jump when vacancies happen. And it's not fair to just assume that everybody's paying market rent, because they're not paying market rent. They're going to start paying market rent later. So having said all that, GRM is great when you don't have price control. When you do have price control, it becomes a lot harder to calculate. And until recently, 15-year-old buildings built after 1979 were all exempt from price control in San Francisco. And so there was a marketplace here in San Francisco using a very traditional GRM analysis to determine values. People looked at current property rents and said, okay, current rents are X, and the building value is 8 times that, or 7 times that, or 9 times that, or whatever the current GRM is. But you can't do that under rent control without taking serious risks on one side or the other. And you actually have to look at, unless you're buying a 100-unit building with 95 people paying market rent expected to leave in 3 to 5 years, that building can do a traditional GRM analysis close to. But little buildings with numbers of problem tenants are harder. to do. So long, complicated answer, but the bottom line is the thing that people need to understand under rent control is that there's a whole set of landlord practices, preferences, rules of thumb, GRM valuations, et cetera, that don't work precisely under rent control. And so the trick under rent control is to take those rules of thumb and figure out how they need to be adjusted to accommodate the fact that rent control is going to impede your ability to get current fair market rent for your unit. So long answer to a simple question. And the real answer is you got to talk to your broker, because I have no idea whether the GRM is 8 or 10 or 12 or 2. I mean, I know it's not 2, but you know, it's a number that changes over time. And it's probably fluctuating it's probably very uncertain right now because we don't know what the Fed's doing with inflation, whether the Fed's going to be able to stop it and whether inflation is going to continue. And so the GRM is going to be, I'm guessing right now, pretty hard measure to grasp. But it's a real.
I hope Brian enjoyed that, because it's probably more than he bargained for.
I know, but the short answer to Brian is go call your realtor and find out what the current GRM is, and then have a conversation with him about any particular building to see how far off it is from every unit is empty or every unit is occupied by current fair market rate paying tenants who are expected to leave in 3 to 5 years. Because as soon as you start changing those, your any standard industry-wide GRM is not going to be useful anymore, except adjusted for those factors. So it's complicated in San Francisco, and the bad thing about rent control is you can't do it the simple, stupid way. But the good thing about rent control is if you're being thoughtful and thinking clearly and making good judgments, there are opportunities to make money here that are not available in a standard Modesto type non-rent controlled. Well, Modesto's now got statewide rent control, but say another state without rent control, Texas, for example. Texas is great, no regulations, no prospect of regulations. Go there and invest your money and know that rent control is probably not coming there. Rose has a question for you, Ray. Tenant made unauthorized changes to the unit. They built in a bar, they installed sheetrock to create a flat wall to mount a television. They dark stained the kitchen cabinets, they changed the light fixtures, they laid vinyl squares over my existing sheet linoleum, etc. Questions: what is wear and tear? Are these types of things included in wear and tear? What process is required to deduct from the security deposit? Does the inspection have to, does the process need to be in writing? What happens if I didn't comply with the statute? Can I deduct from the deposit based on estimates? Can I deduct for loss of rental income while repairs are done? What do I do if the damages are more than the deposit? So basically the whole security deposit process question is there.
Okay, we're going to deposit school. So step 1, wear and tear. None of the things you described are wear and tear. Wear and tear is what happens from normal use, and it's like the paint wearing down. It's the window or the stove running to the end of its usable life. These are improvements. The residential lease doesn't usually allow the tenant to do any improvements. So if these things got done without consent, there's a pretty good argument that you get to undo it as part of bringing the unit back to its original condition. And there's a whole process. It requires written notices. That's a notice of a right to a pre-move out inspection. There's some magic statutory language you're supposed to include in there. Assuming the tenant accepts, they don't have to want a pre-move out inspection, but you want it to. The most information you can get out on the table during this process about what you're planning to do so the tenant can respond to that, the better. So at the pre-move out inspection, you have to give the tenant a list of everything that you think you might deduct for and how much. And that gives them an opportunity to fix it before they go. At the final inspection, you check the condition. If there are remaining defects, you have 21 days to send an itemized list of everything you're deducting for. If you don't comply with this stuff, you technically don't have a right to deduct from the deposit. And that's a risky decision for a few reasons. First, if you're wrong, there are unhappy penalties that the tenant can get. That's in addition to a refund of whatever money was improperly deducted, they can get treble damages, which is, 3-time penalty. And that process introduces your former tenant to a tenant lawyer because they've heard about getting back their security deposit, they've heard about penalties, they want that money, they need it to give it to the next landlord. And during that meeting, the tenant lawyer is thinking, can I turn this into a bigger case? How did you end up leaving? Did you leave because the condition was bad? Did the landlord ever harass you? How about those historical rent increases? It's a can of worms that you don't want opened. So, we advise real caution in playing around with the security deposit because it just could be the kickoff to an unhappy litigation. You can deduct based on estimates, but you don't really want to. It is only allowed if a repair can't reasonably be done in the 21 days. So you're going to get into an analysis of what's reasonable. And the truth is, most of these repairs can at least be scheduled or bid in that period. So, if you can, you definitely want to attach receipts. If you do end up going with the good faith estimate, that gives you a new deadline because you still have to provide a receipt eventually. It just has to be within 14 days of actually doing the repair. You can't deduct for lost rental income. The statute has a very short list of things that you can deduct for. It's rent, repair damage, and cleaning the unit. And that includes restoring it back to its original condition. But if it's not in that list, the deposit's not for the charge. Now, you might want to sue the tenant for money. That could be, I screwed up the deposit statute. I don't want to take the risk of the tenant suing me over it. So, give it back to him and sue him for it. Same goes if there's damages you can't recover. If you think the tenant made you lose rental income, that might be a claim you have against them. And same goes for, you have a $2,000 deposit and they did 10 grand in damage. There's no reason you can't sue them for the excess. And your risk in that small claims lawsuit is a lot lower than having got the deposit analysis wrong. So, if you want to fight with your former tenants and you think that they're a good source of money, you're always able to sue them.
But small claims court also results in them going to a tenant lawyer, right?
And I'm sure Paul would tell you that your best source of revenue is your next tenant.
That's exactly what I'll tell you. And the second thing I'll tell you is you should negotiate these items with your tenant. The pre-move out inspection process, even the final inspection process is a perfect opportunity for you to say, it's going to cost me $400 to paint over these purple, black, orange walls you put in here. And if the tenant says, how about 300, you say, how about 350, and you make a deal. And the tenant feels good because they bargained and won something, and they're not likely to go to a tenant lawyer. I had one landlord tell me that he looked at a tenant's apartment and the unit was filthy with pizza boxes from 6 months, 8 months, 12 months old, and all sorts of crap in the apartment. And he was not looking forward to cleaning it up or hiring someone to clean it up. And the tenant said, how about if you take $2,000 out of my security deposit for cleaning charges? There were no damages. The landlord said, done. Tenant was happy. Tenant got some of the security deposit back. Landlord could clean it up for a lot less than $2,000. It worked. That was a great result instead of taking a loss. But I say bargain with your tenant, bargain nicely, fairly, honorably, make them feel like they got something that they wanted, because you want your former tenant to be happy and gone and not, you don't want to see them again, and you certainly don't want to see their lawyer again. So
Paul, John is interested in the Costa-Hawkins Rental Housing Act. First, he wants to know where he finds the updated copy of it. Are they making changes to it?
So updated copies available on all sorts of websites. It is not something for an amateur to read. Whenever I have a Costa-Hawkins question, I often have to go back and read it myself. It makes my head hurt. I don't advise landlords to read the statute and try and figure it out, because their heads, if it makes my head hurt, it'll make your head hurt. You know, if you want a basic understanding, there's the tenants union's got descriptions of it. There's other people that have descriptions of it on the web. Those are probably more useful to a landlord than the actual statute itself. I mean, it's codified. Type in Costa-Hawkins and it'll get you there eventually in Google. And it has been, it's been the subject of desired changes. The tenants want to change it in all sorts of ways. It was on the ballot twice in the last 4 years. Both times the landlords won the battle in the popular vote. There have been bills proposed in the California legislature. There is a high chance that it gets changed, and there's a 0 chance that it gets made better for landlords. So it's subject to change, but it's change in one direction only. So
I will say, if you want the hot news on Costa-Hawkins, you should follow Dean Preston and Randy Shaw on Twitter, because those guys are going to tell you exactly about all of their new ideas about how Costa-Hawkins could go away, or how they could work around it.
yes, if you want to scare yourself and you want to encourage yourself to pay more contributions to small property owners, definitely follow them. Definitely read the Tenants Union website and Tenants Together and all those good tenant groups, because they will persuade you that the political forces in this town and in this state are coming to limit your profits. So
Now a Costa-Hawkins question. What are the rights of a subsequent occupant when the master tenant moves out of my condo?
okay, so assuming you've given 6.14 notices, when the last,
What's a 6.14 notice?
let me step back a second. Under Costa-Hawkins, you have a right to raise the rent to market when the last original occupant leaves. There's complexity in there because children count even though they're not tenants, but someone who moved into the unit after the tenancy started and there's only those kind of people left in the unit. You have the right under Costa-Hawkins to raise the rent to market. That's regardless of whether you served a 6.14 notice, you have that right to raise the rent to market. If along the way you have treated those subtenants as tenants, i.e. you've accepted rent from them, you have communicated with them as though they are tenants, you have signed a lease with them, you've signed an amendment to the lease with them, that will change their status from a subsequent occupant to a regular tenant. And now you got to wait for that person to leave too before you have your Costa-Hawkins right to a rent increase. I mentioned 6.14 because 6.14 is a notice that you give to those subsequent occupants, telling them that they're not original occupants, telling them that their rent will be increased when the last original occupant leaves. That's good from a whole bunch of perspectives. First, it's good from a property management perspective because it doesn't create expectations of rent control in those people's minds. If they read the notice, they will understand that when the last original occupant leaves, they got to pay fair market rent. So that's good from property management. It's not required to get your Costa-Hawkins increase, but it is required to get a San Francisco rent control increase that's based on Costa-Hawkins. And the great thing about 6.14 notices is that the rent board enforces them. The rent board goes out of its way to find that you haven't met the requirements of Costa-Hawkins, or that you've somehow changed a subsequent occupant into a regular tenant by word, deed.
And I've seen it happen in real time. I have been in a rent board arbitration that I thought we were losing because the landlord had done some silly things, dealing with a subtenant, and at the end of the hearing, it came out that we had a 614 notice in the file, and just everything changed. The ALJ was very impressed by it and didn't want to hear anything else the tenant had to say after that point. And I think wrote in the order that it was like a bomb, like a Band-Aid.
Right. I mean, it's the only instance where I can say that you get a better result from the rent board than you do in a court. In a courtroom, the judge would say, well, okay, you served the 6.14 notice, but let's look at each individual action you took after that to see if it makes you, if you somehow made them a regular tenant. Look, if you actually made them a regular tenant, you'll lose at the rent board, but you get a better reception at the rent board. It's cheaper, it's easier. The tenant lawyers know that. It's a no-brainer question. There's no harm to serving a 6.14 notice, and it can, in some circumstances, really help you. Now, again, not required. If you qualify under Costa-Hawkins, you're entitled to the rent increase. You're just raising your risk of loss in litigation, and you're raising your expense of litigation because you're going to be, well, you can litigate the Costa-Hawkins question in the rent board, but I advise against that. If you have a 614 notice, you should be at the rent board. If you have just a Costa-Hawkins increase, you should be in court because you don't want the rent board making those findings for you. Okay, so Anonymous has a question. So Anonymous wants to know, what is the penalty for failure to register rental units in the rent board's new housing inventory?
So we should probably back up for people who don't know about the registry. Starting in January of last year, San Francisco landlords are now required to register the occupancy status of their units. And if it's owner occupied, that's the end of it. If a record owner is occupying it and no tenants, that's it. But if it's not owner occupied, there's a whole bunch of homework. It's who's responsible for management, how do we get in touch with them, physical attributes of the unit, number of bedrooms, size, and if it's rented, information about the tenancy, commencement date, who's in there, or how many people are in there, rent, and the purpose of all this is creating a registry like they've had in Berkeley, where the city knows every rental unit and they know what's going on in the unit, and it's ostensibly for city government to decide what they're doing with the rent ordinance, but pretty clear trajectory towards vacancy control, I think, if the city's allowed. Once they know what the rent is everywhere, there's some chance that they decide what the rent will be. So the question, what's the penalty for failing to play ball? And it's pretty targeted at the moment. So one thing, you're required to give all that information under penalty of perjury. If you lie about it, there's conceivably some potential liability for perjury. But the direct penalty is if you don't comply with the registration requirement, landlords are not allowed to have their license to rent for that time. And if they had one, their license to rent is suspended. And that prevents the landlord from doing their annual rent increases. So that 60% of CPI that you're allowed to take every year, as long as you're suspended, you are not allowed to do it. And if you serve that rent increase, it is not effective. Now, to me, that sounds like a risk of some cascading problem with your rent increases, where you didn't know you were suspended for a few months, a few years ago, and every rent increase you take after that, I'd be worried about. Text of the ordinance makes it sound like the increase pops back into play, but the tenant is not liable for the amount of the increase during that time. I assume they're going to fiddle with that because it's sort of awkwardly written, and I don't see why they're trying to help landlords make good rent increases. So I assume that there's changes coming there. With these new ordinances, they tend to fiddle with how they work.
And bigger penalties come.
Absolutely.
Like you can't collect rent while your license is suspended, for example. That's not in the law now, but that's the kind of thing that will get added to it. I think there's a sensible part of what the city's doing. Once they get 95, 98% compliance, because the deadline hasn't come for everybody, right, Ray? There's still some grace periods.
I don't know about the grace periods off the top of my head.
So anyway, depending on the size of your building, you may not yet have hit the deadline. I forget what the deadlines are, but they're different for bigger buildings than smaller buildings. So the deadline I don't think it's come up yet for small buildings, but it is coming, and you definitely want to do the registration because, you've got to worry not just about current penalties, but future penalties based on past violations. You don't want any part of it. You want to register your buildings, and the one area that is sometimes complicated is stating the amount of rent. And the advice that I have on that score is if there's any complexity or uncertainty or about the rent, you put a number down that you think is the right number, and you put an explanation that says tenant disagrees because of X, or tenant claims Y, or this is a temporary rent based on pass-throughs, or whatever it is that you put. Instead of just putting down a number and living with it, put down the number that you want to put down, but put an explanation so that you can't be seen to have been lying about what the number is. We face that a lot in various situations, but that's, I think, normally that should take care of your problem. You've maintained your position that the rent is the amount you want, or the amount that you think you're entitled to, but you haven't lied about what the rent is because you've explained that there's an issue about it. So.
I've got another anonymous question for Paul. This member has heard horror stories about tenants of unpermitted in-law apartments getting compensated for up to 4 years of back rent. Is that likely? How does it work? And if I have tenants currently in an unpermitted in-law, what do I do?
Okay, so the answer is if your tenants decide to sue you, it is highly likely that they will get that, and it's potentially likely that they'll get more than that. Going back quite a while now, the going rate for an illegal unit that was illegal because it didn't have a certificate of occupancy but was in good shape, so it wasn't there were no habitability problems. It had 2 means of egress, it had heat, it had windows that worked, it had all the normal things of a unit that just didn't have a permit. The going rate for that used to be $30,000. I would say 5+ years ago. Length of time is maybe call it 5 to 7 years ago, counting the pandemic, maybe an extra 2 years in there. The going rate started going $100,000. So, and it goes up from there, depending on, is there actual habitability problems in the unit? Probably goes up. If you've done bad things to the tenant, it probably goes up. If you've tried to get the tenant to leave when you're not entitled to get them to leave, it'll go up. So that number, that 4 years of past due rent, absolutely. That's probably the minimum of what they're entitled to. 3 years, 4 years, there's an argument about the statute of limitations. And the worst part is not only are you liable for that past amount, but you're not allowed to collect rent until you legalize the unit. And even if it costs you hundreds of thousands of dollars to legalize the unit, you have to live with the tenant in your premises, not paying rent, and incurring all sorts of expense to legalize it. So I have told small property owners, the rule of thumb on illegal units is don't rent them. The only time it makes sense to rent them is if lacking that rent means you're going to miss the mortgage and the bank's going to take the property from you, because you're better off with a property with an illegal unit than a foreclosure. Second thing is, if you have decided to rent in violation of my first advice, the tenant in your illegal unit is your best friend. You do not get into fights with them, no matter how much they provoke you, annoy you, irritate you, make false claims about you. Your job is to keep them happy, because if they decide to be unhappy and they go to a tenant lawyer, the tenant lawyer will very quickly figure out that that unit is illegal, and you will have a $100,000 claim on your neck. So what to do about it is you hope and pray for the day they voluntarily vacate, and you sit around and wait till that date, and you make nice with them. That's all the advice that I got from you.
Can't you just legalize the unit?
Sure, absolutely. One choice is you can hire an architect and figure out what it will take to legalize the unit. That's definitely one of your choices. That's actually something the city's requiring. So if you can do it at a reasonable expense, then absolutely it's the right answer, because you're never going to be able to keep that unit. You're never going to be able to rent the unit, and the city is going to figure out that it was rented at one time in the past. So you will eventually be required to legalize it. So the advantage, of course, of legalizing it when it's empty is you have no construction issues with the tenant being there, because there's often some construction work that has to happen. You haven't doing the construction work to legalize the unit may click in the tenant's brain, oh, wait a second, maybe I have a claim, where they ask a friend, landlord's legalizing my unit, what should I do about it? And the friend says, call this lawyer, he'll get you $100,000. And you won't have to pay rent until they're finished with the legalization process. So the problem with doing the legalization process is you put the tenant on notice. So it's a judgment call as to whether you start that now, so that, you know, it's legal at some point. So at least you can be confident that rent payments are rent payments and not loans from your tenant that have to be paid back with interest, which is what I call rent from illegal units. It's not income, it's an interest-bearing loan. So that's, and you know, look, there's insurance that will cover some of this. It shouldn't cover the back rent payments, but it will cover the other stuff. So it may be that the $100,000 is not paid out of your personal pocket, that some or all of it is paid by your insurance company. So it's not always a complete catastrophe, but there's no good path in there for you other than keeping your tenant happy and hoping they leave on their own happily. Hope they have kids or a job promotion or something to get, or they decide they want to move out of San Francisco. You want those people gone, and you don't want to re-rent it until it's legalized. So Donna has a question. Our tenants are responsible for taking out the garbage bins and bringing them back, but the tenants frequently do not take out the bins, and we received a notice from the city threatening fines. Questions: can we make the tenants pay the fines? Is this grounds for eviction? Second question is, circuit breaker boxes are located on the exterior of the house. The tenants have lost both padlock keys, requiring us to break the lock and replace the key. Can we let them know that next time they will be charged for the cost of breaking the lock and key replacement? This is not covered in our lease.
So the garbage shenanigans, you know, if your tenants are causing damage, you have a claim for the breach of the lease. And if you're being fined by the city, I think that is almost always going to come under the compliance with law section of the lease, and you're going to have some way to pass that cost on to the tenant. As far as eviction, forgetting to take the trash out is pretty minor as far as breaches go. It definitely becomes a bigger breach once the city steps in and is fining you. But with this type of minor breach, we're always concerned with has a pro-tenant jury going to weigh, you know, is it okay to evict these people from their rent-controlled apartment because they forgot to take the trash out? So, you know, that's the way the tenant attorney is going to put it. And, you know, I got to think that a lot of tenant jurors say, well, that seems a little extreme. So we always do a incremental approach with stuff like this. You know, I would absolutely send them the notice with a cover letter that says, you know, if you get me fined, you're paying for it. If you keep getting me fined, you're putting your tenancy in jeopardy. You know, and that type of dialogue, escalate, maybe it goes to a notice that's curable, and in all likelihood, they're going to start taking the trash out because it'll look stupid. You know, you can't get fined over the trash and ignore that. And you have the right paper trail, sure, this could be evictable eventually, but I would definitely want to have the right record before I went there.
And what's the chance that after you spend, say, $5,000 or $10,000 on a lawyer, and the tenant's lawyer offer a stay and behave agreement, what's the chance? how much sense does it make to turn that down?
0.
Okay, so it may cost you $5,000 to $10,000 to get compliance. So just so you know.
And the circuit breaker is a pretty similar question. So we've got a circuit breaker on the outside of the house. If that box requires padlocks to keep it secure and your tenant's losing keys, I don't see it as an issue of that specific key being covered in the lease. So the rent ordinance says you have to give every adult in the unit a full set of keys. I think that's mostly talking about the keys to the door, but if other keys are required to operate the property, you probably owe the tenants one set of keys per adult. And any additional keys, rent ordinance says you're allowed to charge the tenant for it. Rent ordinance says you're allowed to refuse more keys if it's unreasonable. But certainly your cost for rekeying and providing replacement keys, that doesn't need to be in the lease. The rent ordinance says you get to do that. And if this is really just about securing that box, I think you're essentially at the tenant's maintenance obligation. If they lose all the keys to the box, then you need new keys and you have to rekey it. So that seems like a cost that you're passing through to the tenant because they didn't maintain properly.
So this is also a property management question. So if your tenants can't handle keys, put on a combination lock on the padlock, because then you just have a number that you can write down, and even if the tenants forget it, lose it, whatever, you have it, you can open the box, you can tell them how to open the box. So one of the things on all these kind of problems is the tenant lawyer is going to tell the jury that if this ever turned into an eviction problem. So do some creative property management solutions.
And I'm not sure your tenants need access to the breaker boxes.
Well, they need access if the electricity goes off. You don't want to have to pay an electrician to go down there and turn the electricity back on if the circuit breaker lasts.
I guess it depends on how often the circuit breaker is tripping.
Right.
There's some risk that they're in there fooling around with it, and there's some risk that you don't want to go down and fool with it yourself.
Right. So look at all the, it's partly this is a property management problem. This is, if you live in the building, your tenants don't need access to the circuit breaker box in the normal course. If you are living in New York City, then you either need to have a property manager dealing with this for you, or you need to have someone trusted in the building or a neighbor that you trust or something. I mean, there's a property management issue in here. There is need to get in the circuit breaker box. There has to be a practical way for the tenants to get in if they need to, and if you don't want them in there fooling around and you want to know about when the circuit breakers are flashing because maybe there's a problem that needs to be fixed that's unconnected to just flipping the switch, like the tenant is overloading it or the tenant's doing some misdeeds, you may not want them to have access to the box, and you may want to pay the electrician to go down and investigate every time it happens. So this is not law. This is property management. This is treat your property in a way that works practically in the circumstances. More important than
Gloria has heard about a new law. For buildings with 4 units and more, tenants can form a tenants union. What's the impact of these tenant unions on landlords?
There are two main issues with the tenants union. The first issue is that you cannot retaliate against the tenants for forming the union. So that you can't say I'm evicting you because of it. You can't say I'm giving you a rent increase because of it. You can't do any adverse actions against the tenants because they formed this union or joined the union. The other thing is you have to, the landlord, some important person with responsibility on the landlord's behalf, has to meet quarterly with the union so that they can complain about the building and tell you all the things you're not doing as properly as a landlord. If you are doing good property management, I see the chance of a union being formed as pretty low. If you are actually repairing things when they need repairs, I also see the chance of a tenants union being low. If you are not doing your job as a landlord, there's a high chance of a tenants union. If you are in the process of trying to figure out ways to evict them, They may form a tenants union to try to globally fight your eviction. In that circumstance, you might need to be really careful about what you say at the meeting with the tenants union. I don't believe that there's a bargaining requirement as there is with a labor union. Labor employers have to bargain with labor unions, but I don't read the ordinance as requiring negotiation. It just requires a quarterly meeting. So you have to sit and meet with your tenants quarterly. If you are actually available to tenants to talk to meet, and you respond to written requests promptly or reasonably at least, I'm guessing you won't have any quarterly meetings. These are going to happen in the buildings where maintenance isn't being done right and where landlords are trying to do various misdeeds. I don't expect to see a lot of unions in buildings that are managed properly. Carol has a question. Carol has a duplex where she lives in the lower unit and she rents out the upper unit. She finished some work on the upper unit. After the tenants vacated, she's ready to re-rent. Friends are saying because of the eviction moratorium, even wealthy tenants can move in and just not pay anything after the first month, and there will be nothing at all that I can do about it. People stay free and then they leave town with no way to find them afterwards. Should I wait to re-rent the upper unit until the eviction moratorium is lifted? Is there a risk that the moratorium be indefinitely extended month after month after month?
So if you're really worried about this scenario, I think you should watch the movie called Pacific Heights. It's a horror movie where the tenant only pays the first month of rent and won't leave. So yes, there's a risk of the moratorium getting extended. We talked about San Francisco reimposing its non-pay moratorium on July 1st. And, we're 2 years into this pandemic. We're, I think, over predicting when it will end because every one of those predictions made us look foolish reading 3-month, 6-month-old emails. The pandemic will go on and the moratorium will go on as long as there's political capital for it. The city government gets kudos for protecting tenants, and it's hard to argue with the way the moratorium is currently worded because it's not exactly a get out of jail free card. It's not a total ban on evictions at this point. It is a non-pay moratorium when the tenant is financially suffering due to the pandemic, not due to any reason. So they have to tie their monetary problems to the pandemic, and they have to not be able to pay the rent. So the hypo here is I rent to wealthy tenants. They're not going to qualify if they're so wealthy. So you should be able to evict them anyway. And what's more, moratorium doesn't stop your other remedy, which is suing people for the money. And if you got somebody with a good job and assets, they are not going to want to be sued for money. They're not going to want to have an unpaid judgment mucking with their credit. So the idea that tenants who can afford the rent are just going to pay 1 month and then escape into the night, I think means you're not picking a good tenant. And the world changed when the pandemic happened. People's income levels changed drastically because the business closed and they lost their job. But today you get to say, what is my new tenant's job? Why are they in town? Are they really just going to disappear and move out of state where I can't find them in a few months? I think people got rattled because the world changed a little bit. But I think creating new tenancies today has a much lower risk than your tenancies that were ongoing at the beginning of the pandemic. But it's definitely a decision. Do I want to rent property in a city where they're going to protect tenants more than in another city? I think that's always been a question in San Francisco and will continue to be.
Yeah, I think what it says is tenant selection is critical. It always has been in San Francisco, but the moratorium makes it more so. If the person has been paying their rent to their existing landlord in San Francisco during the last 2 years, and they have a good reference showing that they promptly, timely paid their rent, and they have a good job, there's no reason to think that you're gonna fall into this scenario. If they've been through 4 landlords during the pandemic, or they won't tell you who their landlord was or something like that, then that raises red flags and you should be concerned about that. But tenant selection is critical. This is where rent control is different than non-rent controlled jurisdictions. You are married to this person for life or close to life. And so you need to be more careful. You can't just say, this person could come up with first and last month's rent and I'll just take my chances on whether they can pay along the way. That's not the way it works here in San Francisco. You're better off taking a little less rent from someone who's got a solid job that's not going anywhere. You're also, then that's also balanced by, you want to pick someone who's going to leave in 3 to 5 years voluntarily. So lots of different criteria come into tenant selection in San Francisco. I would not be afraid of this problem. This does, if you're doing good tenant selection. Now, tell me you just throw in randomly anybody in the unit that has a shitty landlord tenant history. That's a bad idea. Then I'd go without rent until I found a good tenant. But tenant selection is critical here. One thing for you to consider, the standard small property owner's lease does not include an attorney's fee provision requiring the loser in litigation to pay the winner's attorney's fees. If your primary concern is that you are going to have a relatively well-off tenant who's going to refuse to pay the rent out of spite, you might want to reconsider that decision and put in the attorney's fees clause. I don't recommend it, but it is a potential solution to this particular problem. Because if you have to sue the tenant in small claim in a regular court to collect rent, or you have to sue to evict whenever the eviction moratorium allows you to evict, it will make sure that the tenant is ordered to pay your attorney's fees. We generally advise against it. We certainly advise against it if tenants are not paying very much rent, because they're never going to have to pay those fees, even if you get a court to award them. But you might want to put an attorney's fees clause in your lease if your concern is that you've got a wealthy person who's just going to defiantly not pay the rent.
Well, Noel is a master tenant who has been having problems with his subletters. The rent board told him that he should include language that waives their renter rights in their sublease agreements. I have a few questions about that. One, if he didn't do that already, can he insert that exception by a notice changing the terms of the subtenancy? For new agreements, should he use this ironclad version published online by Broke-Ass Stewart? And is there a legal way to get around the proportional rent requirement where he's required to, apportion the rent between him and his subtenants according to how much space they have?
You want to leave out his editorial comment, or you want to leave me to say the editorial comment?
Oh, did I miss something? Why should Noel not benefit from the rent control that he earned?
Okay, so the first thing I will say here is that there is an astonishing number of cases at the rent board where the dispute is subtenants asking for rent refunds because they were overcharged by their master tenant. Historically, those were almost non-existent. Subtenants were usually paying less than what they would pay for fair market in a brand new tenancy, and so the master tenant was splitting, as it were, to some greater or lesser degree, the difference between market and the rate. So the master tenant was still profiting, but he wouldn't profit as much as he would if he was charging market rates, and the subtenant gets a little bit less than a market rate, so he's happy. Those, as if you read rent board rulings, they come out weekly, more and more of the cases are seeking rent refunds, and the subtenants always win, and that's because the subtenants are entitled to win. This master tenant is in no different a position than a landlord who comes here and says, I signed up for $400 a month rent in 1983, and I'm pissed off and I don't like it. And I bought the building and I own it and I'm entitled to charge whatever I want. No, you're not. Rent control says that owners are not allowed to charge whatever they want, and that master tenants aren't allowed to charge whatever they want. The master tenants, the purpose of rent control is not to make a profit for master tenants. The purpose of rent control is to protect tenants from having to pay more rent to line the owner's pocket. It's not a master tenant profiteering statute. I don't believe that you can fix that by a notice of change of terms of tenancy, because I believe the rent ordinance says it has to be in the original rental agreement with the subtenant. So I think it's too late to fix it. I did not look at Broke-Ass Stewart's ironclad version, but it doesn't take much. Essentially, what you're telling the subtenant is that they are they are roommates of yours, and they're not entitled to protection from eviction because owners are allowed to evict roommates. Master tenants are allowed to evict roommates without just cause, because the idea being that owners and master tenants shouldn't be forced to live in the same space with someone that is annoying, harassing, irritating them in a way that may or may not be a breach of the lease. So you're allowed to evict them without cause, but they're still entitled to price control protections in both scenarios. Roommates are entitled to protection from rent control, and roommates are entitled to protection from illegal rent increases and illegal initial rent charges. What they're not entitled to is you're entitled, or what the landlord, whether they're an owner or a master tenant, they're entitled to evict without proving just cause, but they're only allowed to do that in the master tenant situation if that's in the initial agreement with the subtenant, because the idea is that the subtenant needs to understand when he starts, hey, if I don't get along with the master tenant, I gotta go. I can't stay. So it's designed to protect the subtenant from thinking he has rent control, well, prevent the subtenant from thinking that he has protection from eviction. He is entitled to protection from rent increases, and he's also entitled to a retaliatory eviction defense. So even if there's no just cause requirement, if your subtenant goes to the rent board or to you and says, I want back all the extra rent I paid you over the last 4 years, 3 years, 4 years, statute of limitations, sometimes there's a fight about it, sometimes 2 years, whatever it is, and he wants a refund of that, in theory, you could evict him without just cause, but that person has the right to assert that the real reason you're evicting him is because you're trying to profiteer on the unit, and you clearly think that you're entitled to profiteer from the unit because you've earned rent control. It's very funny. There was an advertisement in town that just slayed me. It was actually some kind of health insurance company advertisement, and it says, I've lived in my body all my life and therefore I own it. It's like, no, that's not how, that doesn't work for rent control apartments. That doesn't, you don't own apartments by living in them. You own things by buying them from the current owner. That's, I'm sorry, but that attitude of master tenants are entitled to rent control. No, you're not. You're entitled to occupy the unit, and if you decide you want to occupy a quarter of it, you're entitled to low rent for the quarter you decide to occupy. And if you decide to occupy the whole thing, you're entitled to low rent for the whole thing. You're entitled to that. You're just not entitled to profiteer from subtenants. Ray gave me that one because he knew it would get me going. Julie has a question. My tenant hit one of the garage swing doors. In order for the doors to be operative, both doors have to be replaced. Since she is responsible for the damage, how do I get her to pay for it all? If she doesn't pay, may I evict her?
I think this is a lot like the discussion we had about taking out the trash, about replacing the keys on the lockbox. This is a straight up maintenance question. And, if your tenants are damaging the property, your lease almost certainly has a requirement that they reasonably maintain the property. They're breaching that by breaking your door. So I think you just do the repair and you send them a bill and you tell them this was your fault, you should pay for it. Absolutely, the best way to get the tenant to pay for it is for them to agree to pay for it. If it requires a formal notice and demand, then I would send that. I would wonder what the cost is before we talk about whether it's evictable. What do you think, Paul? Is a broken garage door at that level? How did it get broken is probably a question.
What condition was it in? Was it at the end of its useful life?
Did they drunk drive into it? Did the car get buried in the front of the building and they stumbled out?
Look, it also ties into the other provision that you should have in your lease, which is you should be requiring tenants to have renter's insurance, because if this is a big deal, the renter's insurance will cover it. The other thing to think about is if it's a big deal, you can put the tenant on a payment plan. If it costs $10,000 to fix the doors, the tenant might be willing to pay $500 a month for a long time to cover that damage. There's solutions in there, and look, I think it's also, if it's an old door, there's a compromise in there. Look, I thought the door was going to last another 5 years, and so I really want, and it's a 25-year door, so I want you to pay 20% of the cost of replacement, Mr. Tenant. I mean, there's fair ways to break that down. I mean, you could probably get away with, X dollars a month as long as you're a tenant until the door's paid off. And if you leave early, you don't owe the rest. I mean, there's all sorts of ways you could structure this in a way that makes sense. But if the tenant damaged the door, I think even an oral lease probably gets you the right, an oral lease where you said, rents X dollars, and that's really the whole conversation. I think you probably get damage. You're entitled to it. Whether you're entitled to evict for it is a harder question, but you're certainly entitled to it. Most people, if they're financially able to pay this kind of thing, will pay it. They're not. Most people are. There's an arrangement. I mean, there's an arrangement. You're well off usually. A well-off tenant usually just pays it. A not well-off tenant is probably willing to do a payment plan. So.
Sherman has some pet questions. An existing long-term tenant asked if he can have a pet. He didn't specify if it's a service animal, but I don't want him to bring a pet into the property. I'm pretty sure that the neighbors aren't going to like it. Can I refuse? What can I do? And
so
another question about whether we can raise the new tenant's rent. I think that his next question was already answered in the Costa-Hawkins discussion. So,
no, I think
a long-term tenant who wants a pet.
Yeah, so let me start with the pet. You can have a lease that says no pets. If your lease says no pets, the tenant's not allowed to have a pet. Now, having said that, service animal is not a pet, and an emotional support animal is not a pet. Service animals are like blind people seeing eye dogs. They are well trained, they're certified, they're actually really enabling someone to have something closer to a normal life given their disability. So those get a lot of protection by the law in all sorts of places. The emotional support animal is insane in my idea, but basically if you have any anxiety, and Freud tells us that everybody in modern civilization should have anxiety, and you call some shrink on the telephone and pay him $100 and say, I got anxiety and my pet Fluffy makes me feel better. Pet Fluffy has now been magically converted from a pet to an emotional support animal. and emotional support animals are things that landlords are not allowed to refuse. So whole host of strategies of dealing with that. I had a client who had a no pets clause. They signed a lease. Tenant was supposed to move in at 11 o'clock in the morning. And at 6 o'clock the night before, the tenant said, oh, by the way, I'm bringing my Doberman, which is my emotional support animal. So the question was, could the landlord lock this tenant out? And ultimately decided not to lock the tenant out. Tenant was there for a year, multiple problems, ultimately got evicted, ultimately sued the landlord for wrongful eviction. It was a horrible story at the end of the day. So I get the concern about animals. As a practical matter, you're not going to be able to exclude a pet because they're going to be able to convert it into an emotional support animal. And that is something that there's no good way around. One solution that Nancy Lenvin adopts is she actually encourages and allows pets. She does a couple of things. First of all, she says people with pets have a hard time finding tenancies, and so they're grateful. They are usually willing to pay a little more money than the next tenant, and they're usually hanging on to their tenancy with their white knuckles, and therefore do everything in their power to pay the rent because they don't want to get evicted without having a new place for Fluffy to live, because it's more important for Fluffy to have a place to live than for them to have that rent money in their pocket. And so her only criterion is she interviews the pet. She tells the owner to leave the pet with her for 20 minutes and go away and get coffee and come back. And if she can get along with the pet for 20 minutes and it doesn't destroy stuff and doesn't attack her and she thinks it's a reasonably well-behaved animal, then she signs them up. And
this gets you the pet terrier instead of the emotional support pit bull that is foisted upon you.
Right, exactly. Exactly. I mean, in theory, they could come with the pet terrier and then say, shit, I got rid of that pet because I didn't like it, but I needed an emotional support animal, which is my pit bull. So the pit bull ate the terrier or whatever. But, you know, if you're getting the sense from the person that this is legitimately their pet and people can show whether that's their pet or somebody else, I mean, who knows for sure. But yeah, you could have a bait and switch, or they could have a terrier and a pit bull and they introduce you to the terrier. So that's a problem. The other evil twist on that plan is to have an advertisement that allows pets, and just some oddball coincidence, the people who come without pets wind up getting their applications accepted, and the people who come with pets don't get their applications accepted for some reason, like their income wasn't as high, or I thought their resume was flaky, or the reference wasn't very good, or some reason that they didn't get picked. So you flush out the people who want to sneak their pets in a little bit, because even so, you know, they may say they don't have a pet and then they get one. And they say, oh, you told me in the ad that I can get one, so I've been here a month and now I want a pet, so I'm bringing my pet in. So there's no perfect solution. There's a legal entitlement to have emotional support animals, and there's no really good way to exclude them. So you got to take your chances one direction or the other.
And if you think you got a good cause to exclude, you should definitely talk to a lawyer about it. Because
yes, the client that got the Doberman, the night before, they got me on the phone at like 8:30 in the morning, and like, what do I do? Can I refuse to let them in? It's the law in California about lockouts is pretty bad. There are not a lot of cases about it because landlords don't do it very much. The case law that's out there is old, 70, 80 years old, but in theory, the tenant's entitled to punitive damages for having been locked out. So they're entitled to whatever rent they have to pay to get their new place because they didn't have any time to find it because you locked them out. And they're entitled to punitive damages for being locked out. So you're facing serious liabilities for doing that. This particular owner, knowing what happened later, might have decided that lawsuit was better than the one they got after a year of hassle with the tenants being a pain in the butt, because they were a pain in the butt about things completely unrelated to the Doberman. They may with hindsight say we'd rather have had that first lawsuit than the other one, but the other one they were not guilty of. And my view is you're always better off with a lawsuit you're not guilty of than a lawsuit you are guilty of, if you have to choose between the two. So it's really tough. It's a real problem. It's a problem for landlords that live in the building and they're allergic to animals. It's a problem for all sorts of people. You know, it's a legal issue that doesn't have any good solutions. The second question, I'm reading it a little differently than you are, Ray. He says one roommate left and the existing roommate found a new roommate. Can I raise the new tenant's rent while not charging the rent of the existing roommate? What he's doing there is he's basically creating two tenancies. He's creating a tenancy with the existing tenant to rent half the unit at the old rent controlled rate and a new tenancy with the other person to rent the other half at a current fair market rate. Crazy, crazy. You are buying an argument that you have divided the unit into two units. And now you're going to face a claim that the city says that you should go and do whatever construction work is required to install a kitchen and a bathroom in both sides and to have second means egress in both sides. You are buying a nightmare.
And neither one's a legal unit, so maybe neither one of them owes you rent.
Yes, neither one of them owes you rent. I mean, you're buying problems that are just beyond. I mean, I can't. You know, if you want to pay a lot of money to us, you should go ahead and do this plan. If you want to be sensible and reasonable, you should live with Costa-Hawkins, which is until the original tenant leaves, you should give this new person a 6.14 notice. One thing you can do in the 6.14 notice to discourage profiteering, your 6.14 notice, we sometimes have people state how much the total rent is, so that the subtenant knows from the get-go whether they're being overcharged or not. And it gives them information that enables them to go to the rent board if they want to go to the rent board because the master tenant is profiteering. The law has been arranged and the courts have ruled in such a way that basically landlords have no remedies for master tenants profiteering. We've tried a number of different tricks to get rid of master tenants because they were profiteering, and those basically have all got shot down by the court. The only situation in which you can do something as a landlord is when the master tenant pretends to live there and doesn't live there anymore and just rents out all the rooms to other people. In that situation, you can do something because the master tenant doesn't live there anymore. But if the master tenant is living there, there's really nothing the landlord can do.
Except stir the pot.
Except stir the pot, exactly. Look, the idea is you want to prevent profiteering because you don't want your master tenant. We've seen situations where master tenants were living on the master tenants in like a big unit, like 4-bedroom unit. Master tenant lived in one, rented out the other 3, and lived off of the profits. They had such a low rent for the whole building that the difference on those 3 bedrooms was enough for them to live on. A lot of money, but it was enough to, you know, pay their own rent and pay their own basic food expenses, and they didn't have a lot. They didn't need a lot, didn't want a lot, but they were living off of it. You don't want that happening. You want that person to not be profiteering on the other units because that just encourages the master tenant to stay. When the master tenant's ready to go, he should go. He shouldn't stick around because he's profiteering on the other units. So the 614 notice is an opportunity to tell the subtenants what that rate is and enable them to make claims should they decide to make claims.
Sorry.
Now or later. So I think we're done. I want to encourage everybody to show up next month if you feel safe enough to show up in a month. God knows if the presenters will be there or not, but I think they will. There will be presenters there. It should be good to meet in person. Wear a mask if you're worried, and we'll see you all in person soon.